if you listen carefully to the debate, that concern about the history of regional tribunals was raised on the floor. And of course, it was raised on the floor by the minority. Now, being someone who goes by the values of the Constitution, the values of probity and accountability, I was very transparent in owning up to the history of public tribunals in our country. If you read the memorandum to the bill, I did acknowledge that the tribunals of the past engage in certain excesses that Ghanaians were worried about. And that as a result of that, the bill has been fine-tuned to align with the procedural safeguards and the human rights provisions of the Constitution. In other words, a tribunal that is strictly designed in accordance with Article 142 of the Constitution, that is a regional tribunal, or Article 126 of the Constitution, that is a district tribunal, will definitely comply with the safeguards provided under the Constitution and the laws of the country. And I also made it abundantly clear that the reason why we are proposing that there be a tribunal's oversight committee, which will be subject to the authority of the Judicial Council, is because we do not want a situation where any excesses associated with the tribunals of the past will reoccur under a constitutional dispensation. And that is why I've even advocated before the Committee on Constitutional and Parliamentary Affairs, Constitutional and Legal Affairs, that the Tribunals Oversight Committee should be decentralized. In other words, it should not be an Accra-based entity. There should be regional committees that will evaluate, monitor and evaluate the work of the tribunals. And if there are any excesses, those will be reported to the Judicial Council, and the Chief Justice will take the necessary action. So I am assuring every Ghanaian that the intent and purpose of the bill is to bring about expeditious administration of justice. All right? It is to ensure that citizens, ordinary citizens, can participate in the delivery of justice as envisaged under the Constitution. The Mahama administration is not the one that is saying that panel members or ordinary people should partake in the delivery of justice in the form of the tribunal system. That is a creature of the Constitution. The Constitution itself envisages that where you are operationalizing a tribunal, you set up a tribunal, it comprises a chairperson who the Constitution requires should be a lawyer of a certain number of years standing. So for instance, the regional chairman of a tribunal must be a lawyer qualified to be a high court judge. In other words, the person should be at least 10 years at the bar. And so you have the lawyer who is the expert in legal matters, and then you have panel members, and listen carefully, the Constitution says they may or may not be lawyers. So if we have a situation where enough lawyers are in the system, and or the Chief Justice decides that the panel members should be lawyers, that will not be in breach of the Constitution. As it may. All right, where it is decided that the panel members should be lay persons, I am sure the Chief Justice in his wisdom will be appointing persons of integrity and a level of education that will make it possible for them to participate meaningfully in the decisions of the tribunal. And so I want to assure every Ghanaian that bringing back or operationalizing the tribunals does not in any way resurrect the ghosts of the past, and that the abuses or excesses that were allegedly associated with the public tribunals of the past will not exist under this current dispensation.